Madam President, honorable members of the bench, may it please this court. My name is Gustav Kirchauer. This is my co-counsel and dear colleague Kaitlin Seibert. We appear on behalf of the applicant, Compass Fuel. I will remain seated during the applicant's pleading as I currently have troubles walking and standing. I will speak on the claim, and my co-counsel will speak on the counter-claim. Madam President, honorable members of the bench, as we know from the facts, the present case revolves around the delivery of oil. Our client, Seafuel, contracted with ASVNL. In accordance with this contract, our client delivered 360 megatons of oil directly to FGS in the port of Antwerp. However, for this delivery, our client never received payment. Following this, Seafuel brought a claim for payment of roughly $660,000 plus interest to the Commercial Court of Antwerp. This claim has two defendants. Firstly, our client requests payment from FGS, the company to whom our client delivered the oil. And secondly, our client requests payment from ASVNL, the company with whom our client concluded a contract. The applicant submits that this court has international jurisdiction over the claim. This jurisdiction covers the claim against both defendants. Madam President, honorable members of the bench, I will begin with the claim against FGS. The Brussels 1 bis regulation determines international jurisdiction for civil and commercial matters. Article 7, number 1 of the Brussels 1 bis regulation provides that the court at the place of performance has international jurisdiction over matters relating to a contract. Well-established CJU case law specifies under which circumstances a claim falls within matters relating to a contract. Two CJU cases are particularly relevant for the claim at hand. In its landmark decision Hunter, the CJU held that a claim qualifies as contractual if one party has freely assumed an obligation towards another party. Following this judgment, our client's claim against FGS must be considered as a contractual claim. Seafuel contracted explicitly about delivering 360 megatons of oil directly to FGS. FGS agreed upon this direct delivery. Also, FGS and Seafuel communicated prior to the actual fueling of the ship. When FGS agreed upon a direct delivery, they freely assumed obligations towards our client. This assessment is in line with the reason why the Brussels 1 bis regulation provides for special jurisdiction at the place of performance. Article 7, number 1 of this regulation provides an additional forum for claims related to a contract. In contractual relationships, parties expose their assets at risk when it comes to the execution of a contract. When parties bring contractual claims against each other, they are protected by an additional forum at the place of performance. In the present case, the party in need of protection is our client. Our client delivered 360 megatons of oil to FGS and never received payment. Therefore, first and foremost, our client should be able to bring their claim at the place of performance. As a result, this court has international jurisdiction over the claim.
So your assertion is that there is no written contract necessary, and even though that there is a contract with another party, that is irrelevant.
Your Honor, this comes clear when we take a look at the second case. I would like to introduce, in the second CJU case, I referred in the beginning to two CJU cases, and the second case is flight right. With your permission, I will shortly introduce the facts of this case. Flight right revolves around the passenger's claim for compensation. The passenger brought the claim against the airline operating the flight. However, this airline did not sell the ticket to the passenger. It was operating the flight on behalf of another airline, the contracting airline. this airline sold the ticket to the passenger. The CJU held that the passenger's claim in flight right against the airline operating the flight falls within matters relating to a contract. The fact that the parties to the claim are not identical to the parties to the contract is of no further importance for qualifying this claim as contractual claim. I would like to directly quote a sentence from the flight right judgment, to be precise, marginal number 60. Start of quotation. The application of the rule of special jurisdiction for matters relating to a contract does not require the conclusion of a contract between two persons. End of quotation. The CJU held in flight right explicitly that the cause of an action is relevant for its qualification and not the identity of the parties. Equally to the passenger's claim in flight right, our client's claim for payment is rooted in a contract, namely the contract for a delivery of oil. The applicant requests payment amounting to $660,000 plus interest. This amount, the price for the oil, was undoubtedly specified in a contract. Following this, our client's claim for payment must be regarded to fall within matters relating to a contract under Article 7, Number 1 of the Brussels 1 Bis regulation. As a result, this court, the Commercial Court of Antwerp, at the place of performance, has international jurisdiction.
Excuse me, counsel, you're saying place of performance, and you say the place of performance is Antwerp. Why? Because you could also wonder in which place the payment is due. Is the payment due? Or am I interpreting too literally Article 7.1a?
Thank you for this question, Your Honor. Indeed, there are two obligations to this contract. However, there's only one place of performance, since the place of performance is determined by the place where the characteristic performance is affected. And the characteristic performance to this contract for a delivery of oil is the delivery and not the payment. Following this, the place of performance is here in Antwerp, since here in the Court of Antwerp, the MS Gracious Advancer was due. Thank you, Your Honor. I will now proceed to the claim against ASBNL, the second defendant. Insolvency proceedings were opened for ASBNL in Rotterdam. In the following, I will argue that these proceedings do not affect international jurisdiction here at the Commercial Court of Antwerp. Article 6 of the European Insolvency Regulation provides exclusive jurisdiction for the courts where insolvency proceedings were opened, however, only for claims that are closely linked and derived directly from insolvency proceedings. The applicant's claim is a request for payment. The applicant brought exactly the same claim against FGS. A claim that can be brought against a non-insolvent defendant cannot be considered to be deriving directly from insolvency proceedings. Your Honors, this assessment is in line with CJU case law. In Nickel and Gergner Spedition, the CJU held that the legal foundation of a claim determines whether this claim is deriving directly from insolvency proceedings. This is only the case for claims which are based on rules specific to insolvency. However, our client's claim is a request for payment, and the request for payment is rooted on general civil or commercial law.
Now, I don't see any defendant, as I mentioned in the introduction, representing this party. So should we examine this jurisdiction or not? Or can you just say, look, no one is coming, no one is contradicting me, so he assumes that you're the competent court?
Your Honor, you should consider the jurisdiction regarding the claim against ASBNL. Also because the claim against ASBNL could have further implications for this whole proceeding. when it comes to the counterclaim.
Okay, in any case, you're correct that we should examine our jurisdiction. But my second question in this regard would be on the basis of which facts? Because you claim it's an ordinary invoice that we're asking payment for an ordinary invoice. Can we just rely on what you assert to be the facts, that it is just the payment of an invoice? Can we be certain, for example, that you did not file the same claim already in the insolvency proceedings? What should or what can we do as a court? How far can we investigate what you assert?
Jonna, thank you for this question. If this court issued a judgment in our favor, we could still apply for execution from the insolvency estate. Then it would become clear that our party can only request payment once and not twice. It is our argument that this court has international jurisdiction over the claim against ASPNL, and the question whether this claim can be executed is a question that will be determined by the Dutch insolvency court.
Okay, and last question in this regard. Wait, I lost it. Oh, yes. Well, according to most insolvency laws, once insolvency procedures are opened, you're barred to, as an individual creditor, to file a claim against a debtor who is insolvent. What would be your reply on that?
Thank you for this question, Your Honor. The European Insolvency Regulation provides that the effects of insolvency proceedings are governed by the law where those proceedings were opened. In the present case, insolvency proceedings were opened in Rotterdam. Therefore, Dutch insolvency law applies. The insolvency proceedings, as I said, were opened in Rotterdam, and therefore we need to take a look at the Dutch Bankruptcy Act. The Dutch Bankruptcy Act provides that claims requesting payment from the insolvency estate cannot be exercised during bankruptcy. However, this stay of proceedings under Dutch national law is limited to the assets of the insolvency estate, and the payment from FGS to ASPNL does not fall into the insolvency estate. ASPNL simply acted as a transmitter. Therefore, no stay of proceedings affects international jurisdiction here at the Commercial Court of Antwerp.
Okay, thank you.
Madam President, honorable members of the bench, at last I will shortly argue why the UNCITRAL model law on cross-border insolvency does not have any effect on the applicant's claim. Your Honours must bear in mind that the European Insolvency Regulation is primarily applicable. As pointed out before, the law applicable to the effects of insolvency proceedings depends on where those proceedings were opened. The insolvency proceedings for ASPNL were opened in Rotterdam and are therefore governed by Dutch national law. However, the Netherlands have not adopted the model law on cross-border insolvency. Following this, the model law is inapplicable. Madam President, honorable members of the bench, concluding this pleading with regards to international jurisdiction over the claim, the applicant submits that this court is competent to hear the claim against both defendants. Your Honours, unless I can be of any further assistance, I refer to my co-counsel. Ms. Seibert will continue with the counterclaim.
Okay,
Thank you.
Madam President, honorable members of the bench, here honorable opposing counsel, good afternoon. My name is Katrin Seibert, and I'll be presenting the issues of the counterclaim regarding the cost of the placing the workers and the reputational damage on behalf of the applicant Seafield to them. I will discuss the jurisdiction of the counterclaim, the option to take evidence in Spain, and the applicable law to the counterclaim. Having the aforementioned in mind, the applicant will be making 3 further submissions today. I will argue that this court is not competent to hear the counterclaim, that this court cannot send a court-appointed expert to Spain, and that Panamanian law is applicable. I will now turn to my first submission regarding the international jurisdiction of the counterclaim. I will show that this court does not have jurisdiction neither under the Precedent Bis regulation nor under Belgian national laws. First, it must be established if the counterclaim falls under the general scope of the Precedent Bis regulation. Neither the general rule of Article 4 nor any other special heads of jurisdiction of Article 7 provide jurisdiction in this court, since these provisions require the person being sued to be domiciled in a member state. And since our client, the applicant Seafield, is now the respondent, the requirement of the domicile is not met, and therefore Article 4 and Article 7 do not provide jurisdiction over the counterclaim. The counterclaim at hand falls under the scope of Article 8, paragraph 3 of the Precedent Bis regulation. However, this article does not establish jurisdiction in this court. I will now lay out the reasons why in detail.
I'm sorry, could you clarify? I thought you started by saying that Brussels 1A was not applicable because the defendant was domiciled.
No, I have stated that the Article 4 and the Article 7 do not.
Okay, those specific articles, and now you will elaborate why also Article 8.3 is not applicable. Okay, sorry.
Yes, it is the applicant's submission that the counterclaim at hand generally falls under the scope of Article 8, paragraph 3. This article provides jurisdiction over a counterclaim in the original court, in the same court as the original claim is pending. It needs to be emphasized that only the original respondent needs to be domiciled in a member state. In contrast to Article 4 and Article 7, under Article 8, paragraph 3, it is not necessary to protect party from outside of the EU from being subjected to the Precedent Bis regulation. As applicant Seafield themselves have decided to sue in Antwerp regarding the claim, consequently they do not have to be protected like a respondent who did not sue in an EU court beforehand. Since FGS, the original respondent, is domiciled in a member state, the requirement is met, and Article 8, paragraph 3 determines the jurisdiction over the counterclaim. Therefore, the counterclaim generally falls within the scope of the Precedent Bis regulation, and consequently, the primacy of the Precedent Bis regulation as European law excludes the application of national laws. Thus, the Lex Fori, the Belgian private international law, is not relevant to determine the jurisdiction over the counterclaim.
So, excuse me, counsel, which instruments should we apply then? So, we're not allowed to grant ourselves jurisdictions based on Brussels 1 bis. We also can't fall back on our own Belgian private international law. So, what should we do then?
It is the applicant's submission that the counterclaim generally falls within the scope of the Precedent Bis regulation. However, it does not provide jurisdiction. Therefore, to establish jurisdiction, it must be fallen back onto the general principle of actor secutor forum rei. Therefore, the jurisdiction will be given in Nigeria.
Okay, so on a general principle of law. Okay.
To establish jurisdiction in the same court, Article 8, paragraph 3 requires the counterclaim to have arisen from the same contract or fact as the original claim. A close connection is not enough to establish jurisdiction. In the case at hand, the claim and the counterclaim do not stem from the same origin. While the claim is aimed at the performance of a contractual obligation, the payment of the disputed amount of money, the counterclaim seeks damages for the cost of displacing the workers and the damage to reputation. Furthermore, a separate legal and factual assessment of the claim and the counterclaim will not have an effect on each other. Whether FGS has to pay CFU or not has no impact on the counterclaim for delictual damages. Therefore, the loose connection between the facts of the claim and the counterclaim do not suffice to establish jurisdiction according to Article 8, paragraph 3. And consequently, this court is not competent to hear the counterclaim at hand. I will now proceed to the second issue, the taking of evidence in Spain. Hereby we submit that this court cannot send an expert to Spain as it does not have jurisdiction over the counterclaim. First, it must be highlighted that the port in question is the largest port in Spain and the fifth biggest in Europe. Due to its size and importance, it cannot be assumed that the premises of the port are freely accessible. The port is managed by the APBA, the Port of Algeciras Bay Authority. It is a public organization that belongs to the Ministry of Transport, Mobility and Urban Agenda. To not violate the sovereignty of Spain, the recast evidence regulation must be applied to ensure legality of the evidence taken in. The recast of the evidence regulation allows foreign courts in civil and commercial matters to take evidence directly in another member state through collaborating. This taking of evidence is governed by the requesting state's law. Therefore, Belgian procedural law determines the option of taking evidence at this stage of the proceeding. Article 875 bis of the Belgian Judicial Code states that a judge may only order investigation measures if the admissibility of the claim is undisputed. However, if we take into consideration that this court does not have international jurisdiction, this requirement is not met. Therefore, this court cannot send an expert to take evidence in Spain.
Okay, and I have some questions about your line of reasoning. First of all, and the less important one is that it's always dangerous.
You decided that in places connected to public authority and where in locations where the access is prohibited or restricted to certain persons, the evidence regulation must be applied. This is also the case here, since the court is governed by a public organization belonging to the Ministry of Transport, Mobility and Urban Agendas. That's it.
To it, or maybe, if I can interrupt, would the answer be different if, for example, it wouldn't concern the ship, but for example, a car that would have been stolen in a car repair shop in Spain? So, I'm making just a hypothesis. So, for example, if you go away from the specific facts of the case and judge let's assume it's about a car that's in a Spanish repair shop, would that change anything with regard to the possibility for us?
Of course.
Hold on to
What the CGU decided in Program is that in places where the public authority restricts the accessibility, the evidence regulation must be applied. However, in cases where the place is freely accessible, other measures can be taken that do not violate the sovereignty, but still a foreign court cannot on its own motion send an expert. It would be needed an informal agreement or arrangement or another public contract, not public contract, but international.
But I think the respondent asks for an expert to be sent there, so it's part of our debate. And in those circumstances, can we or can we not allow?
In these hypothetical circumstances,
No, it's not hypothetical. They really ask us to appoint an expert to go to Spain.
in this particular case at hand, no, we need to apply the evidence regulation.
Yes, okay. And why we're willing to?
Yes, and returning to your second question, Article 1 of the evidence regulation states that the taking of evidence must be in accordance to the member state's law requesting the taking of evidence. If the law of the member state that requests determines that at this part of the proceeding, taking of evidence is not allowed yet, then the evidence cannot be taken. And since Article 875 fifth of the Belgian Digital Code states that the admissibility needs to be undisputed, this is not the case, and therefore it is not possible to take evidence in this stage of the proceeding.
And would this measure to appoint an expert not being submitted to national law then, because you are referring to national law? Why the resolution on evidence is applicable?
Can you please paraphrase the question? Wait.
Why you refer to national Belgian procedure law? So, on what is the basis of your rejection to appoint an expert? Is it Belgian national procedure law, or is it then that is applicable, or what is applicable then, according to him? According, as I see your answer, you say no fishing expeditions as long as the claim is not as admissible. You cannot appoint an expert. That's your that's your claim or your assertion. That's what Belgian law says. So it would be according to Belgian law, man. According to Belgian law.
Yes, correct, Your Honor.
Okay, thank you.
Okay. I will now turn to my last submission regarding the applicable law to the counterclaim. First, it must be highlighted that it's the applicant's submission that the intermixing happened due to a leak in the vessel's fuel tank. If we take this into consideration, the case at hand does not constitute a tortious claim as then was self-inflicted. However, if the court comes to the conclusion that the intermixing happened prior to the delivery, the counterclaim is non-contractual and Panamanian law applies. My co-counsel has previously discussed two important CTU cases regarding the existence of a contractual relationship in a chain of contract. Now we need to assess if the damage at hand is contractual or non-contractual. In this context, we need to look at two other CTU cases, Hoxita and Campbell. In these cases, the CTU held that the claim for damages is contractual if a contract is indispensable to determine the lawfulness of the respondent's behavior. However, if the unlawfulness stems from a breach of obligation imposed by law, the claim must be qualified as non-contractual. In the case at hand, the quality of the oil laid down in contract between FGS and ASB Americas is not indispensable to determine seafood's conduct. It is not the quality deficiency, the high sulfur content, caused the damage, but the intermixing. Providing oil intermixed with water does not in any shape or form meet the requirements of fuel. It constitutes hazardous waste. It is irrelevant how high the sulfur content is. As long as it mixed with water, it cannot be used as fuel. Therefore, it constitutes a violation of general obligation to exercise due diligence imposed by law. Thus, the counterclaim must be regarded as non-contractual and falls within the scope of the REN 2 regulation. In the case at hand, the scope of the REN 2 regulation encompasses both types of damage, the cost of replacing the workers and the reputational damage. It needs to be emphasized that even though Article 1, Paragraph 2G of the REN 2 regulation excludes violation of privacy and personality rights from its scope, however, the reputational damages at hand do not fall under this exception. To interpret this provision, the intended purpose must be taken into consideration. This exception was proposed to limit privacy infringements to natural persons by the press or the media. Companies like our client Seafood and the respondent FGS do not have personality rights concerning private life or personal feelings in a comparable way to a natural person. Rather, company personality rights are centered around economic interest.
Do you have case law that backs your claim?
This was not decided by the CGU yet. However, this intended purpose was laid down in the proposal of the Rome II regulation.
The actual pending one, or the previous one, the one that led to the actual Rome II, because we have now negotiations going on for the new Rome II, which would try to include defamation.
From the original Rome II
And came. And so your assertion is that companies do not have personality rights.
Your Honor, we need to differentiate between personality rights that are explicit to natural persons and especially to celebrities concerning their private life, and personality rights concerning companies. These are centered around economic interests. Of course, companies have personality rights. However, the purpose of this provision was to limit privacy infringements by the press or the media in this case, and to fulfill the purpose of this provision, the wording must be reduced not to include the reputational damages at hand.
Okay, so Rome II applies to the whole counterclaim. And to which law does it lead?
Having established that the whole counterclaim is governed by the Rome II regulation, I will now continue elaborating why, according to Article 4, Paragraph 3, Panamanian law is applicable and non-lex specialis within the regulation takes precedence. In the case at hand, the vessel's motor broke down shortly after leaving the port of Antwerp. However, according to clarification question 6, establishing the exact location is factually not possible. It either happened on Dutch or Belgian waters. This highlights that for tours occurring on national waters, using the ship's ever-changing location will lead to arbitrary results. Therefore, in the cases of maritime tort, Article 4, Paragraph 3 of the Rome II regulation is the general rule rather than the exception. The only continuous connecting factor in the cases where the damaging event is limited to one vessel is the flag state, as it is regarded as the place where the harmful event caused the damage. This was held by the CGU in DFDS Tour Line. The event giving rise to the damage occurred solely on the MS Cursor Advancer. The facts of the case do not indicate the pollution or further spread of the fumes in the surrounding area. To quote the facts of the case in the second page in the first line, the facts clarify that the workers were infected due to the toxic fumes inhaled when repairing the motor of the vessel. This does not even indicate a spreading of the fumes across the entire vessel. The fumes might be toxic in an enclosed space of the engine room, however diluted, they do not have the same effect. This is also the reason why Article 7 of the Rome II regulation regarding environmental damage is not relevant in the case at hand. It requires an adverse change in natural resources such as land, water, or air. No facts in the case indicate that the surrounding environment has been severely affected or permanently damaged. Therefore, Article 7 is not applicable in the case at hand. Taking everything into account, the damaging event is limited to one vessel, and thus the flag states law must be applied to provide legal certainty as a continuous enacting factor. This court,
But can you again elaborate? Because
cyclist.
well, Article 4.3, as I see it, it's an exceptional article, and so it's when one or two, unless it's manifestly more closely connected to another country. The criteria is not what would be the most easy, not that the naming in law would be so easy for us to apply. I look at my co-counsel. But what are your arguments to say the law of the flag is most closely connected?
Thank you for this question, Your Honor. In maritime torts, we need to differentiate between internal and external torts. They are internal and the damaging event is limited to one vessel. In the FTS tour line, the CGU held in those cases where it is internal, the place where the flag state must be regarded as the place where the harmful event caused the damage. And therefore,
But was that on Rome 2 or Brussels 1?
on the Rome II regulation.
True. Because there the criteria is the place of the damage, not the event.
Okay, that's wow.
And so it would be the last element for both? Also the reputational damage?
Yes, Your Honor. Since the primary damage is the breakdown of the motor, and the use coverage is, according to clarification question 24, a result of the inhaling of the fuels and the replacing of the workers, are an indirect consequence. And Article 4 of the Rome II regulations state that irrespective where indirect consequences are the primary damage is the deciding factor of the applicable law. And then, of course, in the system of the Rome II regulation, later articles take precedence over the general rule of Article 4. However, we have already established that the requirement of Article 7 regarding environmental damage is not fulfilled. In the same manner, Article 5 does not apply, and thus Article 4 prevails. Article 5 of the Rome II regulation on product liability is irrelevant as the bunker was not marketed. The requirements of Article 5 are that the product caused the damage and was marketed in the country of acquisition. The term marketed is not defined by Article 5. However, it is to be understood as an offering the product for sale. Therefore, a promotion to a wider audience or an endorsement through the internet is needed to be classified as marketed. In this case, however, the bunker fuel was not offered, but it was requested as a special delivery in the country of acquisition. Therefore, the bunker oil cannot be considered offered to the public, nor consequently marketed. With the requirement not being fulfilled, Article 5 also does not apply to the case at hand. As no special rules apply, the general rule of Article 4 determines the law applicable as Panamanian law. In summary, we request on behalf of our client, the applicant Seafuel, that this court will first assume jurisdiction over the claim against FGS and ASBNL, but dismiss the proceedings concerning the counterclaim against Seafuel due to the lack of international jurisdiction. Second, not state the proceedings regarding the claim against ASBNL. Third, deny the request of sending a court-appointed expert to the port in Spain. And fourth, apply Panamanian law to the counterclaim. Justices, unless I can be of any further assistance, these are our submissions. Thank you.
Okay, thank you very much. Perhaps one final question on the sending of the expert. If you refuse us or if you ask us to refuse to send an expert, then how should we gain the evidence?
Since it's the applicant's submission that this court lacks jurisdiction.
So if we accept jurisdiction, you will accept the sending of the expert.
That is correct, Your Honor.
Okay, thank you. I think we're within the time. It was a big predator that blocks my view.
Maybe I can cut it and over it.
Yeah, this would perhaps see a bit more, I don't know. Okay, thank you very much for this interesting points of view. I think now it's time to hear, I think, the opposite view of the respondent. So you have the floor. Too bad. I'm at the image part of a beaker chair.
With the different space.
To without now the stitch. From
This shapes. It's going to throw one out just have a complete industry.
It's the argument.
bucket.
Repeat it. Do that.
Do down. There that.
Mr. Bath.
Who knows?
I never saw. You understood.
And we better. That's yet. You still have the pros part.
Madam President, honored members of the Fourth
And respected representatives. Payment.
My name is Matei Glitschare, and I speak on behalf of the defendant, FGS, alongside my co-counsel, Kael. I will cover the first two claims or submission, and my co-counsel will then cover the third and the fourth one. Before I begin with my submission, I wish to draw this court's attention to the critical issue at hand, namely, the approach to interpretation and application of European law which best realizes its underlying purpose. The great Pierre Pescator illustrated that the Court of Justice of the European Union relies primarily on the teleological interpretation, which stays true to the purpose-driven functionalism of European law. By doing so, the Court of Justice identifies and safeguards the objectives pursued in a given case. With this in mind, we kindly ask this Court to follow the claims of our submission and give effect to the underlying objectives of both the Brussels 1 bis and the insolvency regulation. Today, I will be covering two claims. In my submission to the first claim, I will demonstrate why this Court does not hold jurisdiction to hear the claim against FGS. Alternatively, should this Court decide to hear the claim, I will demonstrate why it should hear the counterclaim as well. In my submission to the second claim, I will demonstrate why the insolvency proceedings are indeed relevant for the claim against ASB Netherlands. May it please?
Fine.
Regarding my submission to the first claim, it needs to be pointed out that the dispute at hand arises from paragraph 1 is restricted to cases where there exists a direct contractual bond between the claimant and the defendant. The Court of Justice of the European Union has only exceptionally derogated from this general rule. It was done so in the case mentioned by the respective representatives of the claimant, Flightry, and another case that was failed to be mentioned, the case Air Scandinavia. The respective representatives of the claimant illustrated the facts of the case. However, they omitted two important facts which determine the applicability of this case for the case effect. Firstly, the case Air Scandinavia and Flightright concerned a case of consumer protection. In that judgment, the Court of Justice of the European Union only exceptionally ruled that an obligation was really assumed despite the lack of a contractual relationship between the parties under specific consumer protection rules, which provided that when a flight operator executes an obligation towards a consumer with whom he is not contracted, he does so as if he was contracted. Therefore, it was predictable for the claim to be brought against the air company, which was not initially contracted with the consumer.
Excuse me to interrupt you, but is the mere fact that Flightright concerned consumers enough to say it's really restricted to consumers? Because could we not, by analogy, argue here, like the claimant more or less did, that by contracting with ASB Americas, which is a sister company contracting with ASB Netherlands, which is a sister company of the Americas, you could assume that it's one contract, no? Should you really divide the different because they all belong to the same mother company? Is there that argument to be made? I don't know.
Thank you for your question, Your Honor. The fact that this case concerned consumer protection is indeed relevant, as the decision was made based on a directive which is made for consumer protection. Secondly, the connection between the consumer and the air companies and the ASD Americas and ASD Netherlands in this case is much different, as per clarification 63, there was no link between ASB Americas and ASD Netherlands, and they conducted business as independent companies.
The council, you indicate, are two separate contracts, but the ship of your clients got shields. So how would you explain that from a judicial point of view?
Thank you for your question.
Was it a mistake or were it...
Thank you for your question. The fact that sea fuel fueled the ship which belonged to FGS constitute merely the obligation between sea fuel and ASD Netherlands, which was merely performed for MGS. Despite of this, MGS remained contractually bound exclusively to ASB Americas, or, as was also pointed out by the facts of the case, ASB Americas asked FGS to pay to ASB Netherlands, not to Seafuel. Therefore, it clearly remarked the two contracts to be separate. To continue, another case where the Court of Justice of the European Union interpreted the free assumption obligations widely was the Phoenix case, which was not mentioned by the respective representatives of the claimant. That case concerned an actio pauliana, which had two specific features which make it inapplicable in the present case. The actio pauliana is meant for the protection of contractual parties against detrimental acts concluded by the contractual partner, the third persons, and also requires the awareness of the third party of this detrimental effect. Additionally, Ashif Bob agrees in his opinion that Article 7, paragraph 1 should not be stretched to cover such situations. He pointed out in paragraph 65 of his opinion that such stretching of Article 7, paragraph 1 would be too strenuous and too remote, as it would essentially establish that any conduct of a contractual party which affects its assets may be construed as a matter relating to contracts with third persons. To continue, the lack of a freely assumed obligation in the present case is evidenced in light of the Court of Justice of the European Union's decision in the case of Neuropen. In that judgment, the Court of Justice of the European Union held that a claim against a maritime carrier is not contractual in nature merely because the claimant and the maritime carrier, that case, were mentioned on the same bill of lading. Similarly, and contrary to the submission of the respective representatives of the claimant, no obligation could be freely assumed in the present case merely because Seafuel's name was indicated on the invoice received by LGS.
Okay, so you're now arguing why it's not a contract, so what is it?
Your Honor, we argue that there is no contractual relationship between FGS and...
But there is some kind of relationship. How would you qualify them?
We would qualify this relationship as a performance of a contract in benefit of a third person, this third person being FGS, meaning that FGS accepted the performance but was not contractually bound to pay to Seafuel. To continue, following the judgment of the Court of Justice of the European Union in the case for will, there are no freely assumed obligations in situations of change of contracts if a defendant does not authorize the conclusion of a subsequent contract from which the action is derived. That is true in the case of FEN, as MGS contracted exclusively with ASB Americas without conferring any implied or express authority to conclude subsequent contracts on their behalf. Secondly, FGS did not confirm the contract between ASB Netherlands and Seafuel. Rather, when they paid the invoice to ASB Netherlands, they merely did so to execute their contractual relationship to ASB Americas, since they were expressly ordered to do so. That is why FGS also denied their obligation to pay to Seafuel in response to the invoice received on July 4th. With this in mind, the fact that MGS was aware that Seafuel was the physical supplier of the bunker fuel, along with their communication regarding the filling of the ship, is contrary to the argument of the respective representatives of the claimant, merely the necessity for a successful fulfillment between the obligation between FGS and ASB Americas on one hand, and Seafuel, ASB Netherlands on the other.
Okay, but my question remains, we have a situation where Seafuel delivered fuel to FGS, who thankfully accepted. So there must be some kind of relationship. Now you just say Seafuel, okay, sorry, thank you very much for the fuel, but we do not have to pay the invoice. How would you then qualify that? Is that then unjust enrichment, for example? How should we assess this?
Your Honor, if this was to be determined as unjust enrichment, it would nevertheless not affect the jurisdiction of this court, as the Court of Justice of the European Union pointed out in the case Hrvatske šume, that unjust enrichment does not fall within the scope of Article 7, paragraph 2, And in other cases, the Court of Justice of the European Union confirmed that unjust enrichment may fall under Article 7, paragraph 1, only if it is connected to a claim which seeks to break back money which was paid under a void contract. As both of these cases are not to be applied in the present case, we reason that unjust enrichment does not affect the jurisdiction of this court. To continue, and to address this court's jurisdiction to hear the counterclaim, contrary to the arguments of the respective representatives of the claimant, this court can establish jurisdiction to hear the counterclaim under Article 8, paragraph 3 of the Brussels 1 bis. As the respective representatives of the claimant have pointed out, the application of Article 8, paragraph 3 is generally restricted against claimants who are domiciled in a member state. However, this court's jurisdiction is supported both by the purpose of Article 8 and the aim for equal treatment of the parties. Firstly, as the respective representatives of the claimants have pointed out, it is the domicile of the defendant inside the European Union which constitutes the main connecting factor to establish jurisdiction under the Brussels 1 bis. In order to establish special jurisdiction, an additional connecting factor is required. When it comes to the evaluation of counterclaims, this additional connecting factor to the court takes the form of an already existing proceeding between the involved parties. That is in line with the purpose of Article 8, which is to establish the jurisdiction of a single court for closely connected claims. Accordingly, Professors Reinhold Geibner and Professor Stefan Neibler reasoned that the domicile of the claimant should be disregarded when evaluating counterclaims, as it is an irrelevant and unnecessary condition, since jurisdiction of a court already stems from the existing proceeding between the involved parties. Secondly,
Contrary to the wording of Article 8.
Indeed, Your Honor, the wording of Article 8, paragraph 3 is clear. In the event that this court deems that the purpose of Article 8 is contrary to the wording, it may pose a question for preliminary ruling, and here for the Court of Justice of the European Union, whether this word of the law may be crossed or not. Alternatively, if this court concludes that Article 8, paragraph 3 stands firm, it may establish jurisdiction under the national law of the...
From me? Is it not a bit a dangerous proposition to say when an author says that it's contrary to the purpose, he can just disregard the text of a regulation?
Your Honor,
I mean, we're judges.
a risky approach, and that is why we pose jurisdiction under Article 8, paragraph 3 only as an alternative should jurisdiction be established, and are well aware that the Belgian national law was the inspiration for Article 8, paragraph 3, and that jurisdiction may therefore also be decided under the Belgian national law.
And if we go further on the wording of 8.3, which was also what the claimant stressed, it should be the same contract or facts.
Thank you for your question, Your Honor. Contrary to the arguments of the respective representatives of the claimant, the counterclaim in question indeed arises from the same facts as the claim. As a preliminary point, Professors Muirbat and Professor Andrew Dickinson point out that this condition should be interpreted widely as it contributes to the sound administration of justice in the European Union. The counterclaim in question seeks repayment of damages caused by the same bankruptcy for which the claimant seeks payment. Additionally, it is connected to the same chain of events which began with the filing of the MS vicious offenser at the port of Athens. Therefore, we reason that the counterclaim in question arises from the same facts as the original claim. With this, I continue to address the relevance of the insolvency proceedings or the claim against ASB Netherlands. Before continuing, I wish to draw this court's attention to the facts of the case one more time. The insolvency proceedings for ASB Netherlands opened on April 21st. Seafuel was informed of the insolvency proceedings on June 3rd and filed a standalone claim months later on October 20. allowing such a standalone claim to be brought and decided irrespective of the insolvency proceedings carries detrimental effects for fair and effective cross-border insolvency, as it limits the effects of insolvency proceedings to the country in which they were opened. With this in mind, I will be presenting two arguments. Firstly, the claim against ASB Netherlands should be filed in the insolvency proceedings following Dutch law according to the insolvency regulation. Alternatively, should this court conclude that the claim against ASB Netherlands does not fall within the scope of the insolvency regulation, it should be stayed in accordance with the UNCITRAL model law on insolvency.
Can I just interrupt you for a small pause? What is the relevance of this position for your position? Are you in any case linked to ASB Netherlands? I mean, we're happy to hear your arguments on the part of a party that is not represented. It will make our lives more easy when we have to draft our judgment, but is it in any case relevant for your position?
Thank you for your question, Your Honor. I believe it requires a twofold answer. Firstly, the consequences of allowing such claims to be heard before the court go over the mere interests of the single party, and that is why we believe it should be addressed before this court, as it carries detrimental effects for the system of cross-border insolvency. Secondly, in the case, we were asked to address the relevance of the insolvency proceedings in general, not only with regards to the interests of ASB Netherlands. To begin with my first argument, contrary to the argument of the respective representatives of the claimant, that insolvency proceedings are indeed relevant for the claim against ASB Netherlands. To begin with, Recital 14 of the Insolvency Regulation provides that the general principles of insolvency law are namely the principles of unity and universality, which call for a single insolvency procedure in which all the creditors participate. According to the opinion of Ager Couples in the case Commission versus MII Semiconductor, it is the purpose of Article 7, paragraph 2 of the Insolvency Regulation to safeguard these principles from being circumvented through standalone actions brought in other member states. I will briefly address the scope of Article 7, paragraph 2 of the Insolvency Regulation. The delineation between the Brussels 1 bis and the Insolvency Regulation are laid down in Article 6 of the Insolvency Regulation, which provides that for the claims to fall within the Insolvency Regulation, they must be directly derived from the insolvency proceedings and must be closely connected with them. However, according to the opinion of A.G. Bobek in the case CT Group, the scope of Article 7 is wider than Article 6, as it covers not only insolvency proceedings, but also their effects. These effects are provided in Article 7, paragraph 2 of the Insolvency Regulation, which provides that the lex juridicocursus must determine the effects of the insolvency proceedings on standalone actions brought by individual creditors. This is confirmed in the case law of the Court of Justice of the European Union, namely in the cases MG Paul and in the case Enefi, where the Court of Justice of the European Union asserted that the lex juridicocursus must determine the treatment of the insolvent debtor's assets in other member states, and it applies not only to creditors who participated in the insolvency proceedings, but also creditors who attempted to avoid the insolvency proceedings, as the claimant attempts to do in the case at hand. Regarding the argument of the respective representatives of the claimant, which pertain to the question of whether assets which are seeked by the claim are a part of the insolvency estate, we reason that the claimant has no special rights which would allow it to exclude these assets from the insolvency estate. These special rights are laid down in Articles 8 to 18 of the Insolvency Regulation, which cover rights such as rights to ring, the reservation of title. However, a situation such as the present case is not covered in those provisions. To continue, the insolvency proceedings, as pointed out by the respected representatives claimant, were open in order. Therefore, the lex quorum concursus is Dutch law. It clearly follows from the facts of the case that the Dutch insolvency official already called upon the claimant to further claim in the insolvency proceedings. We urge the claimant to do so, as otherwise it could not receive payment before this court, and it would give respect to both the purpose of Article 7, Paragraph 2, and the insolvency regulation as such.
In this, of course, you focus on the insolvency law aspects, while the claimant focused on the Brussels 1A aspects. And it's not the question which regulation will take precedence, because the argument was, look, if I file a claim and I call it civil and commercial payment of an invoice, should it not be civil and commercial? Your view is, okay, I take it from the point of view of the insolvency proceedings and the consequences on the insolvency proceedings. But as I've heard from the case law of the Court of Justice, there are quite strict criteria to fall under the exception of the insolvency regulation and leave the general field of Brussels 1A. What would be your point of view on that? Because you have this case ZK, which was also mentioned from 10th of March 22, where the Court of Justice really gave a very broad definition about an action that falls under Brussels 1A and not insolvency, although it was an action by a liquidator.
Thank you for your question, Your Honor. Indeed, in its settled case law, such as the Civic Group case, the Gordon case, the Ustalav case, it is the delineation between the Brussels 1 bis and the insolvency regulation with regards to jurisdiction that is determined by deriving directly from the insolvency proceedings and their close connection. However, we do not argue that the claim falls outside the Brussels 1 bis regulation with regards to jurisdiction, but to reason that it falls within the Article 7, Paragraph 2, which determines applicable law with regards to the effects of the insolvency proceedings on standalone actions, which are primarily civil and commercial in nature.
So the jurisdiction is determined by insolvency regulation of Brussels 1A?
Your Honor, the jurisdiction is determined by the Brussels 1 bis regulation. To continue, as an alternative arguments, the respected representatives, the claimant pointed out.
Okay, but the final way that they've paid to A, B, and L, I can't something on that because we're saying it is based upon the Brussels 1 is, but A is staying to and L, did receive the payments. Does that change anything?
Your Honor, could I kindly ask you to rephrase the question?
The fact that the payment was the payment of the Peru was paid to A, D, and L. Does that change anything? Because you say it's one because Brussels 1 base, but on the other hand, it was A, B, and L who received the payments.
Your Honor, thank you for your question. The fact that the assets were paid to ASB Netherlands is precisely the fact that we reason the proceedings should be stayed, as they are lodged against the insolvent estate, which is the ASB Netherlands, where the money paid from FGS is now located.
But it doesn't affect jurisdiction.
No, Your Honor.
I think your final minute or the final minute has, and last, how much more time do you need? You can have 2 more minutes if you need.
I think a minute would be sufficient, Your Honor.
I'll just speak ahead.
Thank you. To address the relevance of the UNCITRAL model law, contrary to the arguments of the respective representatives of the claimant, this court may use the UNCITRAL model law as it is the procedural lex spoil. According to the clarifications, all the necessary steps for the recognition of foreign insolvency proceedings have indeed been taken. However, this court has not yet recognized the insolvency proceedings. Therefore, the lex spoil concursus does not apply, making the fact that Netherlands did not ratify the UNCITRAL model law irrelevant. According to Article 17, Paragraph 3, a court shall decide for the recognition of insolvency proceedings at the earliest possible time. Therefore, we kindly ask this court to recognize the insolvency proceedings and stated in accordance with Article 20 of the Municipal Model Law, which provides that such actions must be stated when the insolvency proceedings are recognized. Thank you very much for your kind attention.
Thank you. So, here council, you have the floor. Madam President, honored members of the court, and respected representatives of the claim, I wish you all a good afternoon. My name is Kaya Liban, and I speak on behalf of the defendant, FGS. Today, I will allocate 15 minutes to cover the final two claims of our submission. First, I'll explain why this court should use the direct method of taking of evidence and inspect the ambiguities of answer in the court of interference, focusing on the advantages of this method of cross-border taking of evidence. In my second, overall fourth claim, I will determine the law applicable to the counterclaim. May it please the court. In the present case, the only way to take evidence in the court of interference is to follow the evidence regulation. The evidence regulation provides this court with two options to take evidence. The first method is the indirect method, pursuant to Articles 12 to 18 of the evidence regulation, and allows a member state court to request the court of another member state to take evidence courts. The second method is the direct method, pursuant to Articles 19 to 21, and allows a member state court to take the evidence in another member state directly. We recommend this court chooses the direct. Let me explain why. In order to collect all the necessary evidence to decide on the counterclaim, this by the evidence regulation is generally optional, allowing the member state to use their own domestic procedures when they would result in a simpler, quicker, and more efficient way to take evidence. However, as the respective representatives of the claimant already pointed out, the Court of Justice of the European Union held in the ProRail case that when accessing the evidence would require collaboration or judicial assistance from the local authorities, the evidence regulation and its methods have to be followed. Additionally, in his opinion to the ProRail case, I.E. Yaskinen, in paragraph 60 of his opinion, pointed out that the evidence regulation must be used when accessing the evidence is subjected to statutory, legislative, or administrative provisions. In the present case, the vessel is located in the court of interference. As previously pointed out by the respective representatives of the claimant, it is an international port in an exclusive coastal zone of great importance to the Ministry of Infrastructure. This is why, in the present case, accessing it would require collaboration or judicial assistance from the local authorities. Consequently, this court should proceed using the evidence regulation. Due to the following four advantages, we recommend this court chooses the direct method over the indirect method. Firstly, the direct method respects the principle of immediacy, allowing this court to be directly acquainted with the evidence taken. Secondly, it allows this court to use its official language in all procedural and material matters related to the evidence taken. Consequently, the proceedings are more efficient, as the communication between the court and the expert is easier and it minimizes the possibilities of inaccurate translation. Thirdly, the direct method allows this court to use its own procedural law. This is the Belgian law that this court is more familiar with, and under which the current proceedings are ongoing. Lastly, out of the two, the direct taking of evidence is more efficient. The two timelines set out with the direct taking in Article 19, paragraph 4, and the indirect taking of evidence in Article 12, paragraph 1 are different. The first one gives the competent authority 30 days to approve the request, while on the other hand, Article 12 gives the requested court 90 days to take evidence. Additionally, in 2018, the European Commission conducted a study in which they found that the indirect method of taking of evidence can take up to 6 months to be done. This is why the a direct method of taking of evidence is more efficient. I have a small practical question. I mean, because of course we are willing to use this evidence circulation, which works with general forms, as we know. But as you mentioned, one of the advantages of the direct taking of evidence is to avoid the translation problems. But I have the form for the direct taking of evidence before me. In what language should I fill it?
So the form has to be filled in the language of the requested court, so in the language of Spain in the present case.
And what is in Belgium, there is a law that obliges us only to pronounce our pronunciation scheme in the official languages of the country.
So this would not affect the pronouncement of the judgments, as this would only be completion of the form as to request the direct taking of evidence. At the end, the judgment will still be pronounced in the Belgian language, as the findings will be put in.
Okay, so we just have to find a translator to fill in the form in Spanish or in, Spain accepts Portuguese as well, which is not one of my current languages. What about the costs? Who will pay for the expert? You know, the judges have all these different petty questions. When we order an expert, who will pay for it?
Thank you for your question, Your Honor. In accordance with the evidence regulation, the cost of the expert falls either on the parties or as it is under the national laws of the court before which the proceedings are.
Okay. And Spain has to accept our experts, or can it refuse?
I understand your concern, Your Honor. So there are three possible reasons for a refusal of a request. The first one is that the matter at hand is not civil or commercial. The second one is that the form is not adequately fulfilled. And the last one is that the taking of evidence would be contrary to the national law of Spain, to the fundamental principles of law. However, in the present case, it is highly unlikely that any of these exceptions would apply in the present case.
Thank you for the clarification.
All of the above makes the direct taking of evidence the perfect method for this court to take evidence, and it adheres more to the principle of efficient legal proceeding. Additionally, I would like to point out that there is another convention on taking of evidence cross-borderly, the Hague Convention. However, in the present case, it is inapplicable, as first, Belgium has neither signed nor ratified it, and second, the evidence regulation itself, in Article 29, paragraph 1, expressly provides that it prevails over the convention.
I mean, one small question. We may be more comfortable by doing it ourselves. Could we do it just appointing a court expert and send him to Spain? And I assume your client will give him or her access to the ship. So,
Thank you for your question, Your Honor. In the present case, normally that could be possible according to Lippes and the ProRail case. However, as mentioned, the ProRail case expressly provides that the national ways to send an expert cannot be applied when
isn't there a difference between sending a Belgian expert on Spanish railways or sending just an expert to the ship of your client? So maybe one of the two environments is far more safer than the other one. So, of course, you're not allowed to walk on the railway tracks, but okay, here we're sending an expert to the ship of your clients who's willing to collaborate, I assume.
Indeed, Your Honor, we are willing to cooperate. However, entering the port would require collaboration, not afterwards entering the ship itself. And the port is guarded by statutory, legislative, or administrative provisions in the present case. I will now move on to the fourth and final plane of our submission regarding the law applicable to the counterclaim. As previously mentioned by the respected representative of the claimant, and according to the facts of the case, FGS claims it suffered pecuniary and non-pecuniary damages. The first consisting of the cost of extra crew members that had to be flown in, and the second being reputational damages.
For the reputational damages, contrary to the respective representatives of the claimant's submission, the law applicable must be determined in accordance with Article 1, paragraph 2g of the Rome II regulation. It expressly provides that reputational damages are excluded from the Rome II regulation. Consequently, the law applicable must be decided in accordance with Belgian private international law. In addition, the respective representative of the claimant pointed out that the Commission tried to propose that this exception would not apply to legal entities. However, the article and none of the recitals on the Rome II regulation provide that this would be the case. Additionally, in the Borlaug-Suppleisingen case, the Court of Justice of the European Union has already dealt with a matter whether legal entities have personal rights. Even though there was a case under the Brussels 1bis regulation, the Court of Justice indirectly provided with an explanation that legal entities can have personal rights. Regarding the pecuniary damages, I will first demonstrate that they are no contractual in nature, thus the Rome II regulation should be used when determining the applicable law. Second, I will explain why this court should apply lex loci under Article 4 of the Rome II regulation to the counterclaim, as the damage occurred shortly after leaving the port of Antwerp. Additionally, I will explain why Panamanian law should not be applied to the counterclaim. The counterclaim brought before this court should be, as mentioned by the respective representatives of the claimant, considered non-contractual in nature, meaning that it falls under the scope of the Rome II regulation. The Court of Justice of the European Union held in cases Heva Löwe and Athanasius Karpets that matters relating to tort cover claims which first do not fall within the matters relating to a contract, and second, seek to establish the liability of a defendant. According to the Court of Justice of the European Union's ruling in the Brokstede, Vikingervo and Ganadoro cases, a civil liability claim is contractual in nature if the conduct complained of can be considered a breach of contract. In the present case, according to the clarification number 62, no contract was ever concluded between FGS and CPO. Additionally, as pointed out by my co-counsel in the first claim of our submission, there was no contractual relationship between the parties, as FGS never freely assumed any obligation toward CPO. This is why the counterclaim cannot constitute a matter related to a contract. The second condition to deem a claim non-contractual is that it seeks to establish the liability of a defendant. In the Alstom-Mechana case, the Court of Justice of the European Union established that the harmful event out of which the damage arises must be attributed to the claimant. In the present case, the injury of the workers aboard the MS Gracious Avanza was caused by sea fuel, as they allegedly diluted the bunker fuel with water. The contaminated oil caused 80% of the crew to suffer serious injury. The counterclaim brought before this court in fact seeks to establish Seafuel's liability for the damage that FGS consequently suffered, as they had to fly in extra crew in addition to its green image being harmed. In conclusion, according to the Hilveneber and Anastasius Berfili's cases, this counterclaim should be considered a non-contractual in nature, as both of the conditions are fulfilled. In the present case, the law applicable should be determined under Article 4 of the Rome II regulation. The law, Article 4, paragraph 1 of the Rome II regulation says that the law of the country in which the damage occurred shall be applicable to a non-contractual obligation arising out of law. The Court of Justice of the European Union interprets the term place where the damage occurred in cases for insurance and liability as the place where the damage directly resulting from the accident is sustained. Recital 17 of the Rome II regulation further provides that in cases of personal injury, the country where the harmful event occurs must be construed as the place where the injury is sustained. According to the facts of the case, the event which gave rise to damage occurred shortly after leaving the port of Antwerp. This is also the place where the direct damage occurred, the injury of the workers, the immediate victims. According to clarification number 6, the precise location of the place where the damage occurred is yet unclear, as after leaving the port of Antwerp for the high seas, it is only a short distance on the River Schelde before the border between Netherlands and Belgium is reached. However, contrary to the suggestion of the respective representatives of the claimant, this should not impede the application of the law under Article 4, Paragraph 1, and directly take us to Article 4, Paragraph 3 in order to determine the law applicable. Therefore, we kindly ask this court to take the evidence in order to determine whether the damage occurred in Belgium or in the Netherlands, and then apply the law accordingly. According to Professor Magnus, when applying the law under the general rule from Article 4, Paragraph 1, the so-called escape clause set out in Article 4, Paragraph 3 of the Rome II regulation needs to be considered. Article 4, Paragraph 3 of the Rome II regulation provides an exception to the application of lex ultidanmi if the tort is manifestly more closely connected with another country. In the present case, the tort is not manifestly more closely connected to any other country. It needs to be pointed out that the presented connecting factors as that go to the port of performance, the place of performance being Antwerp, the ship being filled in Antwerp, also preclude from applying Panamanian law. Professor Magnus reasons that when a ship is registered under a flag of convenience, such as the Panamanian flag, the applicability of the law of the flag state is questioned. Additionally, in the case that the respective representatives of the claimant mentioned, the flag state was the Danish flag, not a flag of convenience. His reasoning, in addition to the demonstrated manifestly closer connection to Belgium, should preclude the application of Panamanian law, as in order to apply the law under Article 4, Paragraph 3, a high hurdle has to be passed in order to replace the law applicable under Article 4, Paragraph 1. In summary, on behalf of the defendant, FGS, we kindly ask this court to determine that it does not have jurisdiction to hear the claim. Second, to stay the proceedings in accordance with Lex Voie Concursus. Thirdly, to choose the direct method of taking of evidence. And lastly, to apply Belgian or Dutch law. Thank you very much for your kind attention. As regard to the so-called escape clause, Article 4.3, one of the criteria would be the existence of a pre-existing contractual relationship, which according... Oh, does this apply to me as well? So pre-existing contractual relationship, which according to the Advocate General in the State case, should not necessarily be between the two parties. So here you have a contractual relationship that would be clean Nigeria law. Why shouldn't we not take that element into account if we're allowed to do so according to the ECJ?
So in order to apply Article 4, Paragraph 3, is in the court's discretion to see all the possible connecting factors and then upon them decide whether they pass the so-called high hurdle in order to substitute the law applicable under Article 4, Paragraph 1. In the present case, yes, this relationship could be considered, but it's up to this court, this panel, to decide whether it passes.
Then in your view, it's not sufficient.
No, in our view.
Okay, thank you very much.
Okay, so I think
we heard the principal arguments, and I think it's time for the rebuttal. Whereas you allocated yourself 3 minutes, so I think you should be brief. You have the floor. Yes, please.
Madam President, honorable members of the bench, I will briefly address the submissions of my opposing counsel. However, first I would like to address your question, Your Honor, with regards to whether we fall back in general principles regarding international jurisdiction over the counterclaim. Of course, Nigerian courts can assume jurisdiction based on their law regulating international jurisdiction. My honorable opposing counsel argued that flight right was limited to consumer protection cases. In its ratio decidendi, the CJU did not state consumer protection as a relevant motive for its decision. My opposing counsel qualified, answering your question, Your Honor, the relationship between FGS and Seafuel as a contract to the benefit of a third party. A contract with the benefit of a third party, of course, requires a contract having been concluded. The CJU explicitly held that the identity of the parties to a contract is not relevant for its qualification. Following this, if a contract was concluded, which my honorable opposing counsel agreed upon, the relationship the claim based on this relationship must be qualified as a contractual claim. And lastly, I would like to address my opposing counsel's arguments with regards to the applicable law. Given the ever-changing location of ships, applying the law of any other than the flag state would be arbitrary. I would like to illustrate this with an example. A cruise ship driving along the Mediterranean coast. For thoughts occurring on this cruise ship, every few hours a different law would be applicable. My opposing counsel countered the application of the flag state's law with the argument that their ship has a flag of convenience. However, FGS opting for a flag of convenience cannot be held to the disadvantage of our client's claim. Following this, Your Honors, I respectfully submit again that first, this court has jurisdiction only over the claim, and secondly, the Panamanian law applies to the counterclaim. Thank you, Your Honors.
Thank you very much.
And so is there still a serve?
Madam President, honored members of the court, respected representatives of the claimant, I wish to briefly address the points raised in the rebuttal of the respected representatives of the claimant. Firstly, with regards to this court's jurisdiction to hear the claim under Article 7, paragraph 1, and with regards to the mentioned case flight right, we reiterate that the Court of Justice of the European Union, in that judgment, based its opinion or based its decision on a directive which specifically governs the relationship between flight operators and consumers. Therefore, it is clearly evident that despite not having written it down expressly, decision is constituted on the fact that that case concerned consumer protection. The present case is entirely different as it deals with international business between equal bodies where no such special provisions may be relied on. Therefore, the flight right case should not be considered in the case at hand. Secondly, with regards to the respected representatives of the claimant's argument regarding the applicable law, if the appliance of the law of a territory in cases where a flag, where the ship lies under a flag, may be considered as arbitrary, I would like to contest that in this case, the ship was located at the port of Antwerp when it sailed off, and it was located between the between Netherlands and Belgium when the accident occurred. Therefore, applying the Belgian law should not be considered arbitrary, as it is the only connecting factor in this case, which is sufficiently connected to all the facts of the case. Additionally, arguing that the flag of convenience is a disadvantage, I would like to reiterate that the road to regulation determines the law applicable regardless of the parties' interests. We must follow the applicable law which is provided by the provisions. Lastly, with regards to this court's jurisdiction to hear the counterclaim, I add that Professor Andrew Dickinson reasons that no reason is given for such distinction between parties and that it cannot be supported on any view. 4 decades ago, Ajim Mayras asked in his opinion to the case, failing there, a rhetorical question which is still relevant today. namely, where a literal interpretation of the word of law leads to an unjust result, is it possible to rely on a different method of interpretation to avoid this injustice? In the words of President of the Court of Justice of the European Union, Judge Leonards, it is not only possible, it is absolutely necessary. Thank you very much.
Thank you very much for the slide. Thank you very much also for the last inspiring words of Professor Lee. Well, I call him Professor Leonards because he used to be my first international law professor, and that's old. So now he's indeed president of the ECG. Thank you also for this very lively and very interesting debate. It gave us a lot of food for thought. So to stay in my role as interpreter, we will now suspend this court session for further deliberation.